Right. Good evening, friends. And we have with us Mr. P.S. Rajagopal, senior advocate from Karnataka. And we have seen his passion for hammering the points, not only in the court, but also while hammering the legal nuances for a common man, including the lawyers who have a passion to understand various aspects. Though we have started a series with Mr. P.S. Rajagopal on the service aspects, various parts we have taken, we will continue with that part. Be that as it may, since the cutoff date as imposed by the Honorable Supreme Court in the employees pension scheme is coming closer, people actually wanted to understand firstly as to what is the employees fund scheme as such, then what is the impact of the judgment, what is the impact of the earlier judgment of R.C. Gupta, who all could be benefited. Because after the judgment was rendered, we had just seen YouTube and social media gaga to the effect that the employees would benefit substantially. Their lives will have a drastic change. What we said that pension would be a deferred payment. They would have a windfall in their rise in the pension. And why not? If in the end of their life, of the evening of the life, they have served prior to that with the employer, they should get the benefits. But what is the actual trappings, understandings, all these aspects? We can only say that the only mind clicks and rings the right music that we have to understand, if at all, it has to be through P.S. Rajagopal once it has the nuances of any deeper subjects. I'll request, sir, thank you for taking the session forward, and thank you for accepting our invite. We always look upon you and will continue to look upon that. Over to you, sir.
Thank you, because friends, today I can assure you at the threshold that I will be relieving you, at least I will try to relieve you in half the normal time. Because when Vikas wanted me to share my thoughts on this subject, that is pension under the EPS scheme, post judgment rendered on 4/11/2022. I told Bhaiya, this will be over within half an hour. Then he said, no, it will still come to 45 minutes. Therefore, let me try to complete in 30 minutes is my thinking. Friends, in post-independent period, when welfare of the labor was one of the priority agenda of the government of independent India, Provident Fund was given a statutory framework by the Employees Provident Fund and Miscellaneous Provision Scheme 1952. That act was notified on 4th March 1952. It would be necessary to go by experience to understand how beneficial this Provident Fund Act has been, or whether it has been beneficial at all. Some of the employees who come to me and also the trade unions that come to me, they are quite in number. They say, sir, when we joined service, we have no choice but to become members of the Provident Fund. It is a legal compulsion. And when we contribute to the Provident Fund, we contribute with the hope that at the time of our superannuation, from the Provident Fund accumulations, that is employees' contribution and employers' contribution with the interest accrued thereon, we would be able to buy a decent accommodation. But when we retire, we find that it is not enough even to purchase furniture. And I share their opinion as much as the interest that is given as compensation for investment in provident fund has been during most of the years less than the annual inflation corrosion. Therefore, in reality, what has been happening under the provident fund is the interest that accumulates being less than the reduction in value of our contributions owing to inflation. At the end of our service, we get something less than what we have contributed in real value. Let us for a moment, keep this reality aside, because today's endeavor would be to see what are the changes that have come about pursuant to the judgment of the Supreme Court rendered in EPFO versus Sunil Kumar. It has been reported also in AIR 2022 SC 5634. In SCC online, it has been reported, but in SCC, it is yet to be reported. If you look at the 1952 Act, in the objects and reasons, the Act clearly states that admits that the Employees Provident Fund is really an inadequate measure to ameliorate the hardship faced by the employees. In fact, in the objectives, it is clearly stated, I quote, the ideal way would have been provisions through old age and survivors pension as has been done in the industrially advanced countries. But in the prevailing conditions in India, the institution of a pension scheme cannot be visualized in the near future. So Parliament was keenly aware that provisions of the EPF Act, by providing for compulsory contribution to the Provident Fund by the employer at 8 1/3% of the wages and the employee an equal contribution of 8 1/3 is inadequate to take care of the old age needs of the retired workman and his family sometimes. I am using the phrase sometimes, not because families, not with a view to say that family sometimes, but needs of the family sometimes when children are not yet employed. Don't say that family sometimes means some of them may not have families. Everybody will have a family, and in a society like ours, I expect everybody will have a family. Then the inadequacy which was felt by the Parliament was sought to be met by introducing section 6 capital A of the EPF Act with effect from 16th November 1995. 16th November 1995, the Employees Pension Scheme, that is a clause 6 capital A, was introduced into the EPF Act, providing for establishment of Employees Pension Scheme. And look at the glorious provision that they made in 1965. The provision stipulated, the scheme that was envisaged in 1965 was that maximum salary ranking for contribution to employees pension scheme would be 5,000 per month. If you take that 5,000 or even the present wage limit of 15,000 rupees per month, it is less than the salary paid to a unskilled worker in most of the states under the Minimum Wages Act. The subsequent amendments to that, first it was 5,000, then in the year 90, thereafter it was from 28 to 1996 notification, it was enhanced to the wage limit, which was 5,000, was enhanced to 6,500 in the year 2001, and then in the year 2004 it has been enhanced to 6,500. And this 2014 amendment, for the first time, envisaged that the central government will contribute to the pension fund an amount equal to 1.16% of the wages up to a maximum of rupees 15,000 rupees per month. That means the welfare state, which was by the Constitution, which amongst its directive principles of state policy, command the government or the command the state to take care of the old and uninformed from unmerited wants, and to create an economic system in which means of production are not cornered by a few, in which workers are directed to be provided a fair working environment, and workers are to be given living wages. A welfare state having such a huge social responsibility towards the workers, particularly in their old age. Now, what is its contribution to the pension fund under the EPS scheme? Is 1.16% of 15,000 rupees per month. That is about 165 or 168 rupees per month. And we have a huge employees pension scheme to manage this 168 rupees contribution of this program. And this 168 rupees is not even equal to a fraction of the administrative expenses that are meant from workers' contribution to the Provident Fund scheme. Therefore, the entire so-called pension scheme under the EPF Act is notional and nominal, but we should be happy that welfare state has made a beginning by contributing, say, 116 rupees or whatever it is per month towards the pension scheme. Now, wherever a scheme is amended, there will be litigation about either the interpretation or the constitutionality. The 1996 amendment, that is where two things happen. That is, maximum salary reckonable for pension was enhanced from rupees 5,000 per month to rupees 6,500. But with an important provision, that is, an option was provided for the first time under clause 11.3, that is subclause 3 of clause 11 of the employees pension scheme, that with the consent of the employer and employee, the contribution to employees pension scheme may be made on actual salary of the employee where it is in excess of 6,500, and in which case pension will be payable on actual salary, of course, subject to the definition of calculation of pensionable salary. And under the 1996 amendment, the pensionable salary was to be calculated as average of salary drawn during the last 12 months. That became subject matter of litigation because the EPFO, while applying the scheme, felt that this cutoff date, namely, that is the cutoff date was the cutoff date under clause 11(3) of the EPS scheme. Provisor said, provided that if the option of the employer and employee contribution paid on salary exceeding rupees 6,500 per month from the date of commencement of the scheme, or from the date of salary exceeds 6,500, whichever is later. This was interpreted in some quarters, saying that to the detriment of the workers, holding that this gives the date of commencement of the scheme or date of exercise of option and contribution in excess of 5,000, whether that is the cutoff date for eligibility of the employee, from which day this revised ceiling limits would apply, or whether the date is only for the purpose of calculation of the pensionable salary. Ultimately, the Supreme Court settled the dispute in R.C. Gupta, that is 2018-14 SCC 809, where it said, we find that the reference to the date of commencement of the scheme or the date on which the salary exceeds the ceiling limit or dates on which the option exercise are to be reckoned with for calculation of pensionable salary. It cannot be treated as a cutoff date for eligibility. Therefore, under the 1996 amendment, the moment a person exercises option and the contribution is paid an actual salary instead of ceiling limit of 5,000 or 6,500, as the case may be, the employee becomes eligible for higher pension. Of course, if the actual contribution on actual salary is for a period less than 12 months, then his pensionable salary will be not full revised, full salary above 6,500, but it will be a fraction thereof. Therefore, the Supreme Court said this cutoff date is for calculation of pensionable salary, and from the date of the revision in the scheme or from the date the employer-employee agreed to contribute, make the contribution to pension scheme on the revised salary, on the whole salary in full. From that date, the scheme would be applicable to him. And this date, that is date of amendment or the date of option, will be relevant only to determine pensionable salary for the purpose of calculation of pension, and it has nothing to do with eligibility itself. And Supreme Court laid down one important principle while doing so, that is, a beneficial scheme ought not to be allowed to be defeated with reference to a cutoff date, particularly in a situation where, as in the present case, the employer had deposited 12% of the actual salary and not 12% of the ceiling limit of rupees 5,000 or 6,500. Now, at this moment, let me pause and say what is this 12% of the actual salary. 12% of the actual salary is the contribution to Provident Fund. Out of that, what goes into the pension fund is 8 1/3% of the actual salary. Rest will remain as management's contribution to PF, with which we have nothing to do in today's discussion. I'm not saying that if any kind of question comes on that, I am going to say no. Only today I am ready only with the pension scheme. Not that, but let us be focused on the subject of today's topic, which is pension scheme. Then came this 2014 amendment. In the 2014 amendment, two important changes came about, or three important changes came about, I should say. One is, as I was submitting, the maximum salary ranking for pension was enhanced from 6,500 to 15,000. Simultaneously, central government was obliged to contribute under this amendment 1.66% of the salary of the worker up to a maximum salary of 1.16% of 15,000. And third important change that came about was the pensionable salary, which was earlier average of last 12 months salary. It was made average of last 60 months salary. That means during the last 5 years of an employee's service, if there are additions to his salary, and additions will be there because even if let us say employee has stagnated and is not getting any annual increments, but then the dearness allowances increase will be there, because dearness allowance is not something that is under the control of either the employer or the employee, because the cost of living index goes on rising, and therefore as a compensation, which unmistakably is inadequate, dearness allowance is granted. Therefore, during the last 5 months of service, increase in salary will not be commensurately reflected in pensionable salary. These aspects came to be challenged. One is the validity of what happened was about this 1.16% contribution was that. This scheme mentioned that employer and employee, both of them can jointly opt for contribution on actual salary down instead of limiting it to 15,000 rupees cap under the scheme. But in such a case, central government's obligation to contribute to the pension fund would be limited to 15,000 rupees, 1.16% of 15,000 rupees. And on the remaining salary amount, 1.16% will have to be paid by the employer. This is one condition that came about. The employee, it is not by the employer, but by the employee. To get benefit of pension on full salary, the employee was required to contribute for 1.16% of the difference between 15,000 rupees and actual salary. government would continue to contribute up to 1.16% of 15,000. This was one subject matter of challenge. Secondly, and more importantly, the under clause 26 of the pension scheme, the amendments were made in such a way that the pensioners were divided into 4 categories. What are those categories? Employees who have exercised the option under paragraph 11(3) and continue to be in service as on 1/9/2014. Those who have exercised the option and retired as on 1/9/2014. Employees who have retired prior to 1/9/2014 after exercising the option under paragraph 11(3) of the 1995 scheme. These 4 classifications, that is, one is persons who have opted prior to 1/9/2014 and continuing in service, persons who have opted but have retired, persons who have not opted but continuing in service. These 4 classifications were made. This classification was also subject matter of challenge. The Supreme Court in Krishna Kumar's case, that is the judgment rendered on 22nd November 2020, 4th November 2022, with which we are concerned today, made 1, 2, 3 declarations of law. First declaration it made was the 4 categories of employees of the pensioners you have created now under this new amendment. 4 categories of pensioners, namely those who have exercised option before 1/9/2014 and continuing their service. Second, those who had opted but had retired, those who have not exercised option but continuing in service. Third is those who have not exercised option and retired. Fourth is those who have not opted but are continuing in service. Supreme Court said that this categorization of pensioners into 4 categories is illegal. Pensioners form a homogeneous class, and therefore the question of classifying them into mini groups or micro classification within the broadest classification of pensioners is impermissible in law. That was following the famous classic D.S. Nakara, where it said that pensioners form a homogeneous class and you cannot micro classify them based on date of retirement. Of course, it added one important caveat, that is, where it is an existing pension scheme, you cannot discriminate amongst the pensioners on the basis of retirement date. That was applied in the incident case. The consequence of that was that every pensioner, provided they have made contribution on actual salary, by actual salary, they will be entitled for getting salary, getting pension on pensionable salary calculated in terms of the scheme, even if they have retired or they are continuing in service. Secondly, the option under the contribution made under 26 by the employer and the employee, that itself has to be treated as option for the revised scheme. No further option is required, stricto sensu. However, if any option is to be obtained, there was a genuine difficulty in not opting because some of the high courts had struck down the scheme and there was total confusion about the scheme itself. Therefore, as a one-time measure, you give option for another 6 months or 4 months or whatever time stipulated. One most important declaration that was made is about 1.16% contribution from the central government by the recovery. There it said, there it gave a very interesting direction. It said that there is no provision in the Act to make the central government contribute. The requirement of members to contribute at the rate of 1.16% of their salary, to the extent such salary exceeds rupees 15,000 per month, as an additional contribution under the amended scheme, is held to be ultra vires the provisions of the 1952 Act. That is, recovery of 1.16% from the employee was held to be ultra vires the provisions of the EPF Act, holding that there is no provision for that, insisting on recovery of 1.16% for the salary in excess of 15,000 rupees from the employee. But at the same time, the ground reality of the corpus that is available was taken into consideration, and Supreme Court said that we suspend this part of our judgment, that is, holding that there is no provision in law, therefore you cannot recover 1.16% from the employee for the salary in excess of 15,000. We suspend the operation of this part of the judgment for a period of 6 months, so that in the meantime, the legislature, if it wants to set right this lacuna, it can intervene. Therefore, today the position under the 22nd November 2014 judgment is that every employee in respect of whom contribution has been made by the employer and the employer on the actual salary and the employee at the rate of 1.16% of the actual salary in excess of rupees 15,000 rupees. If these two conditions have been fulfilled, that is exercise of option either under the contribution under the clause 26 of the employees pension scheme, contribution of 1.16% by the employee, and then the exercise of option in the extended period now granted. If these three conditions are fulfilled, employee will be entitled for pension on actual pensionable salary. This is one out. Second outcome is the Supreme Court upheld the validity of calculation of pensionable salary as average of last 60 months salary. Therefore, the method of determination of pensionable salary under the employees pension scheme has been upheld. Thirdly, for future, a direction has been issued in the judgment itself. That is, for future, the option under clause 26 and option under clause 11.3, proviso to 11.3, shall be merged into one option. That is, in future, if employer and employee both exercise their option and start contributions of 1.16% by the employee and the 8 and 1/3% on the actual salary by the employer, that itself will have to be treated as option in future. But as on today, to overcome that, they have said you can collect the options. And I am told the Provident Fund organization has already issued a circular. Frankly, I do not understand why this option is required when you have not made the contribution. After all, your entitlement to the pension should flow from three things. One is the contribution as required under subclause 3 of clause 11. Second is your pensionable service. And third is pensionable service. When you have made the contribution, is it humanly possible to envisage that you did not want to opt, yet you have contributed? This is something very strange conclusion. This is something very strange that emerges from the judgment. And I think if the EPFO has not already done it, it should do so now, that the contributions made on actual salary by the employer and employee, that itself should be taken as option. I can't but sign off with a not very smiling proposition, but you calculate the pension under the formula that is available in the pension scheme. That is, monthly pension is equal to pensionable salary into pensionable service divided by 7. What a person would get as pension? It would be a pittance. If you look at the pension that government pays to its own employees under the non-contributory pension scheme, or which is now popularly acquiring the name old pension scheme. Now we have old pension scheme, new pension scheme, and pension scheme under the EPS, that is the Employees Provident Fund, Employees Pension Scheme under the EPF Act. I think in comparison of the three, EPS under the Employees Provident Fund Act, what word I should use, is least beneficial for the working class. Of course, the Employees Provident Fund Act does not use the word worker. It uses the word employee throughout. But still, it is no social security at all. The quantum of pension you give under the EPS is such a pretense that it is no security at all. I look forward to some improvement somewhere in future, where a on retirement, an employee should get at least anywhere between 33 and 1/3 to 40% of his last salary drawn, if not 50%, as is available to the government. Thank you very much. Now, because
Yes.
any questions we can move on to.
Yes. One is that we normally see and we always understand what is the difference between a pensionable job and which is a non-pensionable job, in the sense they would like to understand, like in a pension, there's a pension scheme by the employer itself, and there's an EPF scheme. Like we did one of the sessions as to whether disciplinary proceedings can be initiated after the superannuation. So once who is getting the pension scheme under the EPF, does he continue to remain that his good conduct, which is a prerequisite in a government employee's case, continue, or this EPF can be stopped in that particular case or not? Let's see, there is a misconduct.
The scheme itself does not provide for withholding of or recovery from pension under the EPS, because if you see, it is in effect a contributory pension scheme. Contributory pension to the extent that the employer contributes the makes a contribution of 8 and 1/3% an actual salary, and therefore the question of good conduct under the future good conduct would recede into background, because he is 8 and 12% is the total contribution to EPF. Out of that 8 and 1/3%, he will be contributing towards the pension scheme. And luckily, neither under the pension scheme nor under the Act is there a provision for withholding or withdrawal of pension or recovery from the pension, as you find in the non-contributory schemes of pension, either in the government or in the public sector banks or in State Bank of India. There, of course, there are definite provisions in the rules applicable, which are statutory rules, that it can be recovered or forfeited. But here there is no such requirement.
The next question we have received is, what is the difference between the Employees Provident Fund scheme, Contributory Provident Fund scheme, and the normal pension?
I could not quite get it because
difference between EPF, CPF, and pension scheme. What are the subtle differences between the three?
See, EPF is where the contribution is there both from the employer and the employee, except where in respect of the voluntary contribution in excess of 12% of our salary, there is no matching contribution from the employer. Rest, that is the normal contribution up to 12%. Employer and employee contribute equally towards the Employees Provident Fund. Then in the General Provident Fund, there is nothing called as employer's provident contribution. General Provident Fund is only a long-term savings scheme, which was with an added sweetener, in the sense contribution to general provident fund, deposits made in the general provident fund account were getting some rebate in the income tax. Otherwise, rates of interest maybe marginally 1% or 0.5%. Advantage was also there. But that was not the real driving force for people to go to GPF. Then in the over a period of time, what happened in the employment sector was that some employers, mostly in public sector, they moved from contributory provident fund to a pension system where pension was envisaged as a retirement benefit in lieu of provident fund. Ideally, what should happen in an area like this, where we are talking of old age, and social security measure to protect or support persons in old age. According to me, what should happen is there must be a lump sum payment as we are getting under the Gratuity Act. Additionally, because this lump sum payment is required to take care of accumulated liabilities, maybe, or when we are settling down after demitting office, certain capital expenses become inevitable. To meet that type of capital expenses, a lump sum payment by way of gratuity is needed, and maybe certain amount of provident fund also with or without contribution from, including the contribution from the employer. But most important, medical aid and monthly pension, so that pensioner and his spouse, forget about the family and all, at least pensioner and his or her spouse should be able to lead a life comparable to the life they had, standard of life they led during their, say, last 5 or 6 years of employment. This can be envisaged only by a non-contributory, respectable amount of pension. What I am suggesting is not an idealist view, because judicially, pension has been recognized as a deferred wage. If it is deferred wage, by whatever mechanism you mobilize the corpus for the pension fund, ultimately, the retired employee should get at least somewhere near 50% of the last paid drawn, because that is the subsistence allowance you pay to an employee who is facing disciplinary proceedings in respect of grave misconduct, and you call it as subsistence allowance. If a working employee cannot subsist at a wage less than 50% of the last drawn wages, how do we expect an honest employee who retires from superannuation to lead a comfortable life without that 50% last drawn wage? This is some, I would say that we pay lip sympathy to old age. Of course, advocates would never understand. this aspect of the matter, because advocates feel happy as they grow older, because larger the gray hair they have, higher will be their fee. But a workman would understand his suffering in old age, because what is the pension he gets under the employee's pension scheme? It is nowhere comparable to his last done salary. And look at the other thing. Now for pension, a government employee gets full pension on completion of, I think now it is 20 years of service or something like that. Whereas for the pensioner under the EPS scheme, for a person to get full pension, he has to have been employed for 35 years. Only then, under that formula of monthly pension is equal to something into something divided by 70. For you to get full pension, you are required to work for 35 years. Yes, sir.
Yes, sir. So again, that particular question, where you get the EPF scheme benefit, does it bring the severance with the main master? Because a lot of cases are there where you say that there is a severance of relationship. Now, no disciplinary proceedings will be done.
That scheme is also not there in the employer's pension scheme. That on dismissal, he will lose the benefit and all that, it is not there.
So we can say there is a severance of relationship.
Severance of relationship with the employer, it is definitely severe. Because once you cease to be an employee, this pension fund is managed under the EPS by the EPF organization itself. Maybe within the organization, they create a board of trustees or whatever it is. Ultimately, it has nothing to do with the employer. The moment that umbilical cord is cut and on the date of retirement, it is not where under a scheme floated by the EPF organization. Only monetary contributions are made. Once those contributions enter the EPF organization, the employer loses control over them. See, for example, under the EPF Act, balance in the EPF account is carried over to the new employment. It is not that I work under an employer for 5 years, I resign, then I join a new employer. But for the purpose of employees' provident fund benefits, that employment is treated as continuous, in as much as the EPF balance itself will be carried over to the new employment. Therefore, luckily, as of now, I don't see any provision under the employees' provident fund scheme to curtail the pension on the ground of misconduct. Well, employers may create some problems in signing and forwarding the forms, which is a common feature, because that is what I see in day-to-day operation of law. But that is not a legal. Such actions are not backed up by any provision in law.
Okay. This is by SP saying, where and how does an employee exercise his option if the present employer is neglecting in his responsibility?
Option is to be exercised through the employer, and quoting your account number. And when I saw a query that option forms have not yet been uploaded by the EPF organization. Option forms pursuant to the judgment. I think the senior course would be whether they are contemplating the senior course of treating the making of the contribution itself as an option.
This is joint option form for the post 2014 retired employees has
Yes.
not been uploaded by the EPFO till date.
Yes.
The Supreme Court had directed to upload within 4 months. Now, what would be the way out?
The way out is that the inadequacy of time or non-implementation can always be taken up again before the Supreme Court. Wherever such options, people are finding it difficult to opt, they have to make a representation, no doubt, to the EPF. If there is no response, action and contempt is the only remedy.
Article 129. This is M.K. Sagar. I am in job and I have already provided joint options in the year 2018. Right now, should I be resubmitting my options?
If you have already opted and that has been done, if you have already contributed, I don't think a new option is required to be exercised. Because there is nothing in the judgment to say that the earlier options are treated as invalid or they are of no consequence. If you have already opted option you have given and you are entitled to demand new pension according to the new dispensation.
So thank you, sir, for sharing your knowledge. I think one question has come. Just what is the base year when the pensionable service starts? What if one completes 34 years of service? Should one opt?
That is from the date of joining service. It counts. So that's the entire service need not be after 96 amendment or after 2014 amendment. Past service counts. Only for the purpose of calculation of the pensionable salary. The dates of amendment and dates from which of the contribution is made, they become relevant. Otherwise, the service starts from day one.
Even the latest judgment of Prem Singh says even daily wage, etc., has to be counted towards pension.
Sir, PD roller workers who work from home, they are also employees for the purpose of provident fund. Workers engaged through a contractor, they are also employees for the purpose of EPF Act. Therefore, the nature of service is not important. There is nothing called as permanent service, regular service, or approved service. If you have drawn salary from a particular date, that is the date of commencement of service for the purpose of EPF Act.
So this is our EPS contribution is 8.33% of 15,000 at the moment. We are a member since 1/4/2008. Now we wish to take option, but our employer CPF would be diminished and transferred to EPS. What's the best formula?
If employer says he has transferred the fund to the EPF. But the question is if that contribution has been made an actual salary, that would be the deciding factor. Because if the earlier employer and employee had jointly opted, they would have made contribution on the higher salary. And if the employer does not cooperate in now giving the details or signing the form, you can always take it up through the employer EPF organization, saying that this was the account number of my old employer. This is my continued number under the EPF account. Therefore, reconcile and pay. It is only a question of reconciliation of the account.
Yes, sir. So Thank you, sir, for sharing your knowledge. We are grateful to you as usual, and we will continue with our service law series with you. Thank you, everyone. Stay safe, stay blessed.